Hello, everyone. Maḍayin exhibition is downstairs, which shows close to, I think, 80, bark paintings, beautiful paintings, actually made earliest ones are 1935 up to like 2019. So I wanted to maybe start with how those artists, your new artists, while making those beautiful bark paintings, I believe like their role in the activism, in Australian Aboriginal land rights movement. So maybe actually Professor Davis to comment on sort of like their space, their role.
Yeah, so the exhibition downstairs is pretty extraordinary in terms of that collection of bark paintings. We were just talking in the back room about the Yirrkala bark petitions and the way in which your new people have deployed art in, like most mobs, I would say, but I mean in relation to the fight for land rights, they've used art in the context of not just activism. So the Yirrkala bark petitions obviously came as a consequence of the lease that was afforded to Comalco by the Commonwealth over their lands, and they weren't consulted on that. And then, subsequent, and some of this art is downstairs, in subsequent land rights cases, they've used that art as a part of their evidence in the federal court to assert statutory land rights and native title. So, I mean, I think it just speaks to the kind of symbiotic relationship between their art and their advocacy through the courts for recognition of their land rights.
And Richard, when you were young, well, you're still young, but you also had years working, at the New South Wales Aboriginal Legal Service. That was kind of your starting point, isn't it? As a community worker, and I wonder if you were sort of like aware of what was happening in Yirrkala and.
Definitely, we talked about it a lot actually. Like we were looking at moving things forward. There was after Millirripon versus Nabalco, there was Co versus the Commonwealth in 1976, and we were talking about what we would need to do in the future. And we were looking at taking a new case to the High Court. So I was right in the middle of those discussions, with the other staff at the legal service, mainly the field officers and the lawyers, and we actually were successful in getting a date, or getting the imprimatur to proceed with the case, which became Mabo. I've got to say at this stage that I found the money for the meeting of all the legal services to get together. There was an employment program. I just spent a couple of years in the public service, so I knew about their funding and that sort of thing. So we channeled some of those funds, to put on this meeting. I arranged that meeting where we chose Mabo.
It wasn't easy for legal services to do that reform
No, it wasn't.
work either.
It took us years, to get there.
And I mean, obviously, the legal services started in New South Wales and in and around Sydney, and one of the reasons the Aboriginal Law Centre set up by Garth Netheim and Hal Wooten was set up was because the legal services were so busy and inundated with court work that they didn't always have time to think about other legal issues that needed reform, and this would have been one of those really key meetings.
Yeah. Well, Hal Whitlam he was a Supreme Court judge, or he became a Supreme Court judge. Hal Whitlam was the head of the law school at University of New South Wales. Together with the legal service, they built this course for a field officer training course, that I attended, and that gave me a really strong foundation into the history of the Aboriginal rights movement. So it was like working in the day-to-day.
And that's interesting. So because I'm at UNSW Law where Hal used to be, I don't think they know about that course.
Pardon?
I don't think they know that Hal
Yes,
set that course.
Oh, no, Hal Whitlam was, this is Garth Maḍayin.
Okay.
Yeah. Him and Co and Solly Belair basically got together and they put this course on. It was transformative, for the younger members of the people who went through there. Like there's legendary names that you wouldn't know here, but like Billy Craigie, Isabel Coe, Lyle Munro Jr., George Rose, Stevie Gordon. Just everybody who was involved in the legal services back there, the main players, and then me and my mate, who I'm going to meet in Europe next week, we were the youngest people in this course, and this knowledge that I have, the background, that formed a great part of that, and the discussions around that, of course.
We were talking in the back room about when you first moved to Sydney and just being kind of invited into that world of the Aboriginal Foundation, which we talked about because I think in the history of Aboriginal, land rights and the struggle for rights, not all Australians are cognizant of this group that existed in Sydney.
It's like Opal in Brisbane. They were the kind of the equivalent in Sydney. Opal House in Brisbane.
Yeah. And where all of these issues around political governance and land rights were discussed, and strategy was discussed. And do you want to talk a bit more about that, like what that must have been like as such a young kid coming into this world, and it was the kind of ascendant period of Aboriginal rights.
Yeah, that was our last hurrah, I think. Just said, but like it was phenomenal, to like I landed on the platform at Central Station in Sydney. I was walking now. I was broke, and I needed to get to Queensland, and I'm just walking along there thinking. I look up and there's another black fellow walking towards me. So we acknowledged each other, stopped and talked to him. He asked me, what you doing here? I said, I'm trying to get back to Queensland. He said, you got any money? I said, no. He said, you got a ticket? I said, no. He said, come with me. We went around to the Foundation for Aboriginal Affairs. And he got me a ticket on a train. They booked me a ticket back home to Brisbane. The train didn't leave till the next day, so they gave me this night in a hostel, which was right next door to the Black Theatre, and about 400 metres from the hotel, one of the blackfellow hotels there in Redfern. And then I did half a Rip Van Winkle. I was, instead of staying overnight, I stayed 10 years. So.
I was going to ask, did you go back? Yes. If we just want to talk a little bit about Mabo, obviously Milpram was the first case where Blackburn deemed that, collective rights weren't recognised in the Australian legal system, nor was Aboriginal property rights, or at least they didn't have any form of recognition within the kind of received British property system.
Because they came and claimed it as theirs.
Yeah, they did. And I mean, he did make that comment that he said, you know, if there's any system of governance and laws that I've seen, it is this system.
Yeah.
But he couldn't find it in the common law. And it's interesting to see there's a new book out on the Yirrkala bark petitions and Your New Activism by Claire Wright, the historian, who actually talks about Galarrwuy's response now to Blackburn and his judgment in Milfram, which I won't repeat. It can't be repeated, I don't think, publicly. People can read it for themselves. But that was kind of the, I guess, antecedent to the Mabo decision. But there was a lot that happened after that. For example, we had the Woodward Royal Commission, and from the Woodward Royal Commission, they were able to pull together what became the Aboriginal Land Rights Act, Northern Territory, which was the statutory framework for Northern Territory Aboriginal land rights. And of course, the 10 Embassy very much grew out of McMahon, who was just before Whitlam's rejection of
land rights.
Of land rights. Bizarrely done on the anniversary of the Day of Mourning, which he thought would put pay to it before the election, but instead it set off the 10 Embassy. And of course, after Whitlam went, we saw Fraser implement that statutory framework, but not another 20 years then until we get Mabo number 1. But number 2, sorry, we did get Mabo number 1. For those who don't, for those who don't know, Mabo number 1 was simply that the Bjelke-Petersen government in Queensland said, passed legislation to basically say if native title is recognised in the future, we extinguish all of it. It doesn't exist. But that was overturned by the High Court because of the Racial Discrimination Act. So I wanted to ask you about Mabo number 2 because, of course, it hasn't been the most smooth operating statutory process that has led to the recognition of native title, and there's been a lot of disappointment on behalf of a lot of mob.
Well, it's a racist colonising act.
Yeah, well, like you said, say it how it is. And I
can do that.
We'll talk about compensation and reparation in a moment, but so Keating, 3 kind of outcomes of the Mabo decision were the statutory framework that set up people to make claims. The second one was the land fund, which was meant to be for dispossessed mob, right?
Yeah, but was taken by the people who already had land rights.
Yeah. Well, we'll talk about that too because it's actually something so many mob don't understand, and the rest of Australia. And I think actually more needs to be spoken about that land fund because you're
Absolutely.
right. There was a court case,
and the white people who are working on it, should be removed.
Well, one of the very first decisions made by that land fund was that the money would be used for mostly people who live in the north. And there was a case brought by the New South Wales Aboriginal Land Council and Aden Ridgeway to say, hang on.
Yeah, hang on. We lost the most.
Yeah. Where do the dispossessed sit in that? Mm-hmm. So there's that land fund. And then the third element is this social justice package, right?
Yeah, which never...
Yeah, has never been implemented. Yeah. Never been implemented by any Australian government. And embedded in that, I wanted to ask you in the context of things like reparations. Well, I mean, the question of the social justice package was to our mob, what does repair look like to you? So their answer was, this is what repair looks like to us. And Keating's like, it's too difficult, I'm not going to do that. And then every successive government has just pretended it doesn't exist. And so I wanted to ask you a bit about that because, I mean, that it was called the social justice package.
Yeah.
And ATSIC did those consultations with mob around the country to ask what does repair look like.
What do we want? That's what we need to ask ourselves. What do we want? We don't know because we've never asked ourselves.
So they asked some people, and you kind of got this framework of social justice. But I think you probably have to go back again now and say to people,
I think so.
What do you want?
I think so. That's
because we don't.
Like there's the people in 1965, they protest. The black fellas, I think they're from, might have been Roper River or somewhat.
Yeah.
They were protesting, and one of the signs they carried says, "Ask us what we want." So.
Yeah. And so. It seems to me such a big oversight. And again, people talk about Australia's constant forgetting of really important things in relation to our people and our people's
they're really good at it.
They're very, very good at it.
Yeah.
And it seems to me that social justice package is one that needs to be reignited in terms of that post-Mabo settlement, given that we're actually getting to the tail end of the native title era. And the courts are starting to turn to compensation. What does it look like to compensate First Nations people for the extinguishment of their native title? And we have a big case in the High Court right now called Commonwealth and Yunupingu, and it was one of the last cases that Dr. Yunupingu and his crew brought before he passed, which is what compensation is payable to them for the extinguishment of their native title in a pre-1975 sense, given that 1975 is really key to the payment of compensation with native title because it's when the Racial Discrimination Act was passed by Whitlam.
The restrictions of the Native Title Act, like on the most dispossessed, where we have to prove a continuous unbroken line when the government policy was to remove us from our lands, and put other people onto our lands. So there was, I thought that was more than mischievous.
I was reading about your recollections of growing up, Mitchell and Bob growing up on the reserve, and I was thinking about that in the context of the Yirrkala case, because that was the point where the courts decided that for you to be able to claim native title, as you say, you needed an unbroken connection to country, continuity. That meant if you were removed, and many mobs were removed at gunpoint from their lands to be shifted onto reserves and missions. So missions run by churches, etc., and reserves run by the state. Under legislation passed by state governments, territory governments, if you were moved, that's it. Bad luck.
Yeah. Well, I thought that was ridiculous, but one of the things that I've been curious about is, with sovereignty, there are three elements of sovereignty, that you have to fulfil. There has to be conquest, cession, but under both of which you have to have treaties, or terra nullius. Now, when the High Court, when Mabo, when the High Court overruled terra nullius, that only leaves these two. So, I think native title is a distraction from the reality that the government, the High Court should have instructed the government to get with Aboriginal people and make treaties. That's, and I got a legal opinion on it, just brief, and that was that our position is that we are in an unofficial war.
Well, I mean, Mabo's lauded as a seminal judgment, but they did kind of fudge the sovereignty aspect. Meaning
they completely ignored it.
Yeah, and I think
we should have gone hard at them then. And we didn't then, but we need to do it now.
Yeah, I mean, I think there are some test cases being thrown around about what that looks like to go back to the common law definition, or the common law decision around Mabo, which is very different to the statutory arrangement that was delivered to us. They're two really different things.
Yes.
And so there are a number of people that have been speaking for some time about the need to prosecute a case about the inconsistency between the Native Title Act and the Mabo decision. But what the court did, so as we say, it's a watershed decision, but in relation to the original grievance that still hasn't been resolved in Australia, they kind of said, yeah, well, settlement doesn't work. So you're right, settlement, cession and conquest. They kind of went, yeah, okay, well, it's more of a conquest than what we've always said, which is settlement, but we're going to kind of apply, we're going to say it's that, but it will apply settlement laws, whether it's because the court thought it was easier to do that than to actually wade into a space that people thought was the role of the parliament to do. And I think the point that you've made, which I think is an important one, political resolution of this is really critical.
Absolutely.
But if they're not going to come to that, then people have to continue strategic litigation until you get to a place that... But that strategic litigation takes so much out of people. It costs so much.
Yeah, it costs so much money. It's easier to to make art about it.
Yeah. Which is...
well,
well,
it gets it in the public discourse.
Influential as...
Yeah,
art
and
is as influential as these cases.
protest, in line with protests, like the young people are protesting along these lines now, and I think that moves things along. You have to have this stuff in the background, like these pending cases and that sort of thing. But to get them moved along, you need activism. So that's
I agree. And you need to use all of these levers to push them to some kind of place.
Yeah.
In particular, if you want a political settlement. And I think the interesting thing, although we're on different sides of the debate probably, in relation to Uluru and Australian politics and the law, there you had a kind of offer to the Australian people. And I actually think from all of the research we've seen, it was a very messy campaign, and I'm not sure people really to this day understand what they voted on. But Australian politicians and Australian politics and political elite could not bring themselves to contemplate this settlement, which was, which was actually quite a minuscule reform, right? It was just
I
right
agree.
to be
Like
consulted.
we've already had this voice to Parliament. It was called ATSIC. So and it, like life was better for us, under ATSIC. As much as we criticised them, there was good that was done there.
I think that. I don't think we talk about ATSIC enough. It's kind of just disappeared from
Yes,
the public
I don't think we talked about
discourse.
it enough as well.
There's no analysis of it. People just accept a media narrative that it was terrible, that there was...
Well, ATSIC was this thing, the Aboriginal and Torres Strait Islander Commission, and it was popularly known as Aborigines talking shit in Canberra.
I was going to say, I was thinking, is he going to say what it was called? that is what blackfellas called it. But there's a long history of Aboriginal entities that are what we regard as political participation in Australian democracy. ATSIC was one of them. And I think in the kind of Uluru dialogue process, people were so devastated by its abolition because it was in statute and it was so easily removed after Mark Latham removed Labor's support for it. It was literally taken away overnight. And all of that, especially for regional areas, all this bush infrastructure just removed overnight. And people haven't recovered from that decision.
No, I agree. No.
I think you're right. I think people had a much better life when ATSIC was around. And
I was one of ATSIC's biggest critics. But I do acknowledge that they did good work. And we miss that. I think that's really showing in our communities these days.
And they funded a lot of really important strategic litigation around stolen generations.
Yeah, absolutely.
There were a number of cases that occurred during their period, including Cartonieri and the Commonwealth, the Hindmarsh Island case, where the High Court did actually find that the race power in the Australian Constitution was a racist power. It could be used not just for beneficial legislation, but also racist legislation. And, it is the only constitution in the world that has a provision that allows a parliament to pass adverse negative laws against a people on the basis of their race. The only one. Which I found really hard to stomach during the referendum campaign, where the core argument, and when we do the research, it shows that the core argument people voted no for was because they didn't want race in the Constitution and that they didn't want inequality. And we were just like, but there's a racist power in the Constitution. It's been there since 1901. And the Australian constitutional order is imbued with racism.
Yeah.
I mean, I don't think we have to pretend we weren't a racist country. But nobody wanted to talk about that.
Should be.
Sorry. Yeah. Yes.
Look, I got to say, you know, look, they're really complicated. I'm thinking, you know, like a reset. My next art project is to put together a draft constitution, and I want to take it to the people. I want to go and attend embassies, and go and talk to Australian people about a new constitution. You know, we can look at some of the things that we need, you know, to ensure democracy. Like you can't just ban lobbying, but you can restrict the number of times you can run for parliament. And then when you're successful running for parliament, if you're not allowed to be on a board for 25 years after, well then, you know, like, you got no chance of influence the incoming people. So it's just things like that. You know, like say that for instance that one party can only get 40% of the vote. You know, like, and that's it. And to ensure that there's not a single party rule, because in effect single party rule is dictatorship. So we should be trying to avoid that kind of thing. So I got a whole heap of other shit, you know, that
I think
I don't want to talk about here.
I think Australians would enjoy that conversation.
I'm sure they will. You know, like
because one of the things that we found across the Uluru stuff, but especially last year in the campaign, is they weren't, when we would go out to areas like Logan and others that were kind of not hostile to Aboriginal rights, but they're areas that people just assumed would vote no, right? It wasn't Aboriginal rights that they were voting no on. The problem that I thought was really alarming was they said, why do you, like, you can't trust politicians. You cannot trust the system. You cannot trust Australian democracy. And that's all we heard across the country.
Yeah, well, this is why I'm proposing this reset, you know, like with a thing, you know, like if you've got any, you know, good contacts high up, you know, like in ARC and that sort of thing, you can say, you should look at Richie Bell's Constitution project.
As long as this isn't recorded. No, I think Australians are up for that conversation.
I think so. I think so too. You know, like,
I think the politicians' response post the Voice referendum is, we're never going to go there again.
Yes,
and I'm
that's
like,
right.
That is not the answer to what happened last year.
No. Well, there's a disconnect between the people and the institutions, you know, of power, and there's a distrust. You know, like the ability, the capacity for these people to lie, you know, to us, you know, time and time again, and that it's become acceptable. You know, that the media, you know, has become so, you know, powerful and so centered, you know, like that it's damaged the democratic notion of the nation there. So I think I've got a bit of a problem here as well. You know, so.
I think we've just got enough energy to worry about ours. I think.
I'm hoping that the public service, you know, can just slow, you know, these right-wing nutters down. You know, so.
Just I know Boston voted blue, but just being there and following it, I'm just like, you know what, I can't deal with this. I just got to focus on Australia, and it's just too much for the brain to contemplate, really.
Oh, I'm going to Germany. You know, like where I'm not Aboriginal, where I'm not at the bottom of the social order, that sort of thing. So.
It's a shocking thing to contemplate when you say that, and when so many of our mob have said that over the years, and still saying that we feel like we're still at the bottom of the heap.
Yeah. So
How does in all of this, how does art takes role? What's sort of like a role, activism and art sort of shape together, in these years after Mabo #2 case?
say that again.
How does what's the role of art in the continuations of kind of protest movement?
Look, I
I mean,
think
you're taking a central role in this, certainly.
Yeah.
Yeah, look, I think artists have spoken clearly, and often, about our circumstances. It's basically every exhibition you go to. The artists are talking about the issues. That are in front of us. That's our job.
I mean, yeah, and you in particular, because I think when I think about the big reparations clock, which is extraordinary, I think that's really interesting in the Australian conversation, because there's so many people that just go, so we've done native title, what more do you want? And
Show me the money.
There's these compensation cases going through the courts with native title, but that's not what he's talking about up there.
No.
And I think that kind of thing where it disrupts people's notion that our issues have been dealt with, that's really important, particularly around things like reparations for dispossession.
Well, land back is almost not on the agenda there. It's almost non-existent. It's been bureaucratised out of existence. Our possibility of getting land. Almost every single claim that's been made on country that I have access to has been lost. And it's because of that unbroken connection rule.
Yeah, I mean, you're right about land back. You see it in a North American sense in other parts of the world. But it is something in the water in Australia, isn't about the way things get so hyper-regulated really quickly. And the life of it is kind of taken out of it before it really becomes a thing. There's a lot of kind of land back GoFundMes and proposals here and there across the continent, but it hasn't yet had that prominence that it has had.
No, well, I don't think we have the philanthropic power that the US has, and plus I think Australians are tighter than Americans.
Do you reckon? I mean, so the philanthropic sector, they do say that about Australia, that it's much bigger here because it needs to be, because there's no universal welfare system and there's no universal healthcare system and there's not social housing and etc. in the same way that we have it in Australia.
For those reasons, they're doing it for tax reasons.
Well, and tax reasons. But they say that certain sectors of society have had to step up to the plate here, where there's no provision by the state for those social services. And I think in Australia, I think it's getting more pronounced though, because it's not like we're successfully delivering on the social commitments that we always have.
Well, our social commitment has not even started.
That's true.
Maybe we should be putting more pressure on that aspect of the solution. No. That's the third thing you were talking about, the social justice.
Yeah. I mean, we were just talking before about housing. Mm-hmm. But housing, as you said, was a really integral part of what the 10 Embassy was advocating for as well. These kinds of really important social needs that all humans need, but especially our mob.
Yeah, my first home was a tent. The first 2 years of my life I lived in a tent.
And so many of our mob still can't get leases because people won't lease out houses to Aboriginal people who look Aboriginal and are Aboriginal.
Gee, I had experience with that. Now I just send Milani Gallery to get a house for me.
That's what my mum.
Because I can't get it. I literally cannot get a home on my own name. I will never get it.
True. My mum used to hide us. She's white, but she used to hide us. My dad couldn't go, but she would hide us, so we couldn't go with her to get a lease for anything.
Yeah, well, I used to get white friends, like, or the fair-skinned cousins, to front up.
That's true. Hey, get up. Sorry.
What about some audience questions? Anything? Any of you is interested, or can we go and have a drink now? Oh.
Kind of talk about Ministry Kids and what you're trying to say there, and how the kind of message of the work, and maybe you have to describe it, sorry, and how to think about putting power into the communities that are being most affected by these racist policies, generations of them.
Well, I made the work to. It was a very optimistic work. Well, I photographed 7 children, and I put labels underneath them, and they were made up the ministry of a government. So I had these kids, Prime Minister, Deputy Prime Minister, but it'd be Minister for Rivers and Creeks, and Deputy Prime Minister or whatever, like a Minister for the Attorney General was Minister for the Arts, and there was the last one was the Minister for White Affairs. That's. Well, this is not a touch screen, eh?
It's not a touch screen.
Fuck. Like a female Prime Minister. And you'll notice, go along, I think there's another girls, and a boy and another girl. So it was like 5 of the 7 cabinet members were girls. And I had this other photograph where I had this photo of an angry black man. It was me, with my front teeth out, and
You have it there, right?
and
Thank you.
and that sold out, and I have not sold one of these ministry kids. So I think it's because it's too in favour of women.
What was it called again?
Ministry kids.
The other one of you. Portraits.
Pigeonholed.
Pigeonholed.
I never have pictures of my art, I never have bring along slides or whatever, to my talks, because the technology always plays up, so I don't even bother. And this is one moment when I should have. Yeah, that dude there, like it fulfilled the necessary vision of a black man, angry. So, and it sold. And this really beautiful, optimistic, positive thing gets nothing. Just told you, rich people got no judgment.
Yeah, but Richard, the last image there after Drinker, Taylor, Solier,
Oh, Troublemaker. Yeah,
Troublemaker, and in the current installation of that, and there is still one available, by the way, it's a mirror. So each one is the angry black man, and then when the viewer comes and looks at it, troublemaker,
They
they
are the
actually see
troublemaker.
themselves.
Yeah. The viewer becomes the troublemaker. Maybe I need to put a mirror on the other one.
Yeah.
or make it shiny.
Megan, you had mentioned earlier about the Mabo social justice, I don't know if it was package or whatever it was. I'm curious what was said then, and what did you hear in the Uluru sessions about what people wanted? You know, I'm curious how it's changed over the course of time.
I think the social justice package, for example, doesn't have representative voice in it because ATSIC existed at the time. So it just depends on where you are on the historical trajectory that people are offering up. But it was still pretty much the same core things like, recognition of land rights, culture, compensation, constitutional recognition, like a whole series of things that had been elicited from the groups that they'd consulted around the country. There was one criticism of the consultation they did, and that came from Aboriginal women who felt that they hadn't been properly consulted in the process. So that would be something we'd have to do in a new consultation process. So the Uluru Dialogues, we made sure that there was equal numbers of men and women, and then we, allowed the space for women to have that yarn amongst themselves. People could do it together if they wanted, but we allowed that space for particularly remote area women to be able to talk among their own women. So those, just dealing with the methodology that you use is important to get that kind of information. But it's always the fundamental settlement issues have never really, they don't substantively change from decade to decade just because native titles happened or just because statutory land rights, or we still are. Treaty to one side, because actually when you look at the world, treaty was actually a British Crown method of dealing with First Nations. So treaties pretty much only exist in New Zealand, Canada and the US. And it's very hard to do a treaty in 2024, right? Because you're not going to get the same sovereign to sovereign agreement. They're just not going to play in that space, and treaty's not going to deliver it.
No.
So we have to come up with our own Australian version of what we want. But I think the big lesson of, I've gone off your question a little bit, but I promise I'll come back to it. The big lesson of the referendum is you cannot do this through the politicians. You cannot go the old power path. You've got to work with Australians to get them to that space. That's why I think when you talk about taking a new constitution out to Aussies,
I think it's really important.
I think it's something all Australians are happy to engage in if you can get them on the weekends or when they're not busy across the 151 electorates. But I think it's a conversation that needs to be had, and we've never tried it that way, right? We've always gone through the doors of power. It's just not going to work because of the way Liberal democratic governance is creaking to a halt, as one of the key issues you raise is in those adversarial parliaments. The two major parties dominate, and they've pretty much destroyed Liberal democracy in the form that we know it, and that is the ballot box form that the UN and everybody endorses as the primary form. While you continue down that path, you're just going to have those two dominate, and their allegiance isn't necessarily to the people; it's to a whole heap of stakeholders that we can't see. It's not very transparent who they are beholden to. But what you say about Australia is true. There's this massive conversation amongst Aussies about how the representative system isn't representing what citizens want, and you hear that play out in so many spaces, especially climate change. They're having a conversation for the 1930s and everybody else is like burning. So back to your social justice package, I don't think it's any different. So we've looked at that and then we've mapped it across from 2017 down. It's not dissimilar to anything any mob, if you get them in a room and ask them, will come up with in terms of a settlement package. The problem in Australia is that there still is just politically, there's no sense that actually the original grievance needs to be settled for the nation to move forward. And that's absent of all kind of conversations. And
Yeah,
post...
I agree. They've absolved themselves of any
Yeah.
implication of even benefit. So
And post-referendum, they think they're off the hook now. They're kind of like, yeah, that's done, moving on. And you can see it in Closing the Gap and all the other things that they try to do and say, look, I mean, we know Closing the Gap is failing. Yeah, it failed the first 10 years. We're almost halfway down the second 10 years of version 2 and we're still failing. There's like 2 or 3 indicators that suggest things are moving forward. But one of them that no one ever talks about, there's an indicator in Closing the Gap that's called land and justice, right? Or land justice. And you know what the Commonwealth does? It counts native title and statutory land rights towards the Commonwealth's contribution to closing the gap. So they will, like, I think it's can be in the Northern Territory, they will hold up a statutory land rights claim for 30 years. They will fight traditional owners for 30 years in the courts. Once it's granted, they claim that as a win for them. And same in the native title space. Australians talk about this $30-40 billion that blackfellas get. They don't. The real amount's somewhere around 3-4 billion. But in that money is money that the Commonwealth uses, Aboriginal money that the Commonwealth uses to fund people who object to native title. So they fund farmers' kind of objections to claims over pastoral leases and other things, right?
I oppose native title too. I might get some of this money.
Yeah, I wonder. And so once the native title is granted by the federal court, they claim that as a win, even though they fought it. And so that's just the land justice I'd never understand why anybody, like nobody says anything about this farcical indicator that sits in the Closing the Gap regime, where they're like counting up all the land apparently Aboriginal people own, but say nothing about the trauma that they've put traditional owners under to actually get there. Makes no sense to me. Sorry, I don't even know if I answered your question.
Mahalo. Thank you so much for your sharing this dialogue, this incredible time. I have a question that dovetails with one of the answers that you just gave, but I have another question. I wanted to ask if you could speak more to the current High Court case, but in response to the question that you asked when you mentioned about the complexities of treaty making now and what that would look like, I wondered if you could speak about the devolution to the states. I mean, thinking about Victoria and sort of how that undercuts sovereignty, which both my questions really hearken to something that you addressed, which is, what is this about? I think of settlement in North America is always already tied to the extinguishment of sovereign recognition. Any kind of compensation has typically been about extinguishment. So I just wonder about the question of legitimization of settler colonial government, inadvertent legitimization through brokering some kind of package. So I guess it's sort of interconnected.
I'm teaching all of this at Harvard right now, so I'm just like, I mean, I don't know if I can answer you quickly, but 2 responses. One is, I've forgotten. The treaty. So I don't know. When I've looked at all the material, historical material, I'm not sure treaty was ever meant to be a state territory-based treaty. And then I don't even 100% know whether it was originally intended to be pan-Aboriginal. I mean, I don't know how we do it now. You would probably do what some would call sovereign to sovereign, so nation to nation. So Australia's federal system is unusual in that, unlike many federal systems, over time the High Court has whittled away the rights of states. So the Commonwealth is kind of the king in our federal system. It trumps most things, which is the problem with state-based treaties. The states' constitutions and everything are just ordinary acts of parliament, and so they're easily overridden by the next government that comes in. Also, the Commonwealth has provisions in the Constitution that allow it to override the states whenever it so chooses, and it did in Victoria in relation to the Belt and Road Agreement with the Chinese government during COVID. So So they do exercise that power when they need to, but it does render aspects of the treaty, if it gets done, vulnerable to Commonwealth override, and there's nothing anyone can do about that. Which is the problem of state and territory. Well, territories are worse off because they sit under the plenary power of the Constitution 122. They're not states, so they're just territories, and the Commonwealth can override them whenever they want. So power is a big issue, distribution of power across the Federation when you're looking at treaty. And I don't know how they resolve it. They talk about trying to entrench it, but I'm 100% sure the High Court won't allow that. I don't know how they're going to manage that issue.
Constitution.
In the federal constitution.
Yeah, we have to
Yeah.
get a new constitution.
Yeah. Well, I mean, in the very early 1900s, there was a parliamentary committee on treaty at a Commonwealth level that said you could, and you can, if you wanted to, put a treaty's power into the Australian Constitution. Or you could possibly do them under, maybe, this would probably never happen, but under the external affairs power in the Australian Constitution. Or you could do it under the race power in the Australian Constitution. There's levers there, but it requires a lot of thinking and planning and strategic work with the Australian people first, before you push on into government in that space.
Although you know, like leaders are there to lead.
Yeah, technically, yeah.
Yeah,
Well, I mean, it's
that's what we pay them for.
you look at Canada. I don't know if there's many Canadians here, but you look at kind of Section 34 and 35, sorry, and some of the developments that happen in the post-old man Trudeau sense. Leadership plays a really important part in shepherding that stuff through.
Absolutely.
And I'm not sure we had the leadership there last year to get this across the line. But when I read stuff on treaties and Section 35,
We don't know.
you know, Trudeau looked like a leader who was able to lead a lot of those conversations and push attorney generals in a particular way and get the country from a, you know, like a Bill of Rights to a Charter of Rights and reopen different parts of the Constitution and have that mature and sophisticated conversation with the people to say, you know what, there's something wrong with our Constitution. It's creaking to a halt. Let's have a series of conferences with different cohorts of Aussies and let's see what we can do moving forward, and we'll all vote on all the changes at the same time.
I think it has to be over a long period of time, though.
Yeah.
These discussions have to be, over 15 decades, actually. To embed them in the communities.
I agree.
Yeah.
That's how long it takes to talk
Yes, it
to
does.
Aussies. Yeah,
Yes, it does.
it takes a long time.
So
We have a
There are
one
no quick
actually question or comment over there. Yes.
Yeah, thanks, Megan. And Richard, have you finished, Megan? I don't want to cut
Oh,
your...
yeah, and I was just going to... Oh, but I can talk to you later about the Yirrkala case. Is that what you're...
I wanted to wind back to your comments about the recent moves to, I suppose, reinvigorate common law, Mabo, the sui generis nature of that, as against the legislative measure, and piggyback on the question about treaties, because in the sense of the legislative measures, as far as the 1998, the 10-point plan, basically, I think at that time, Mick Dodson said, well, why not just call it native title for graziers and pastoralists and, and miners and be done with it. And I'd hazard to say that the subsequent period of time hasn't improved. So linking that to the idea of treaties within the states, I'm wondering whether they're just Trojan horses, whether they're meant to placate white Australia that something has been done because we're not as bad as the 1950s, or because certainly the states, I mean, Victoria's flirted with the idea of a treaty, but substantively, it doesn't give any rights. It's a bit like native title talking about non-exclusive possession, which is nonsensical. I mean, the Wotjobaluk people have non-exclusive possession in Western Victoria, and that's the same. I can go into this and exercise the same rights. So I suppose what I'm saying, are they chimeras? Are they illusions and mirages just to massage liberal consciences in Australia, and they're never intended to give any land back to the blackfellas?
I mean, I probably feel like I'm a bit on that end of the spectrum for treaties right now. I mean, I think I often read the UN Special Rapporteur's report on treaties because he sets out the idea of treaties, agreements and constructive arrangements. And I just think, Australia can do those agreements with mob, but they have to be done in a completely different way.
yes,
Like a completely different way.
100%.
Even truth telling,
And
right?
it's going to take years.
It'll take a long time.
Yes.
But even truth telling, you can see like we're not engaging the broader Australian population, and we're adopting these transitional justice models of truth telling that are really adversarial. Well, they're set up like courts under commissions of inquiries. They never work. We continue to complain, all the time about the Royal Commission and other commissions of inquiries where recommendations are never implemented, but we're taking truth telling down exactly the same track.
Yes.
And then we're going to wonder at the end why recommendations aren't. Yeah, because it's the form. But you cannot do truth telling 2024 if you're not engaging the rest of Australia. And how you do that, we haven't yet put our minds to, I don't think. But I don't think the Truth Commission model and the model on offer that's endorsed by the UN and all the transitional justice professionals, I don't think it's going to work. I don't. I think we have to innovate. And I don't know what that looks like.
I agree. We have to innovate. Everything that we've got is not working and will not work. We have to develop things that actually work. And that's going to take a lot of time. It's going to take effort, because it's so difficult to get. The powers that be, who have all this power, to ask them to give up something is quite a lot.
And there's this. So we've just spent the year engaging with the 6.2 voted yes. We say it's going up and up and up. There's a lot of people with buyer's remorse saying we didn't know, but they're a really interesting group of people who are so actively still engaged, signing up to the Uluru stuff, because the next phase is to go out and have conversations with them so that they can talk to the no voters, find out what's going on, what they heard, why they voted the way they did, how they see the future of the country. Because we saw this as a part of a new momentum, given Australia's population is going to very dramatically change in about 10 years, right? It's a really rapidly browning country. Huge numbers of South Asian, Southeast Asian, when you look, so we did YouGov polling around who would vote no and yes. And we did lose some multicultural communities to the no campaign. They were just too good for Yes 23. They were just too organised. And that's a huge cohort of Australians that still want to have that conversation. It's not the Australia of old, but you've got to start these conversations now. You can't wait 10 years. You've got to start now. And so we feel kind of hopeful, but we're not sure whether we should be playing in the treaty truth space if it's just a replication of something that is going to deliver the status quo.